first is failing to keep a current valid address on file with the Department of Health. You're required under your Practice Act to maintain a valid current address. If you fail to do so, it may lead to further disciplinary action against you. Contacting the DOH investigator and providing him or her with a oral statement or a written statement. When you receive an initial investigation, this is the first letter you receive from the Department of Health, it'll have a letter on the front, and it'll state that you need to provide your CV and contact the investigator immediately. You are under no obligation to provide your CV, and you are under no obligation to provide a written or oral statement. Anything that you provide them or say to them will be used against you. It's very important because we see this happen all too often, and you can destroy any defense that you have at the outset of the investigation, simply by making mistakes. Failing to carefully review the complaint and make sure that it is sent to the correct position. This actually happens. Other health deals with physicians and even more healthcare providers. So mistakes do happen and they are made, and it's important that you verify that everything on the complaint, the letter you receive is accurate. Failing to ascertain whether or not the investigation is on fast track, which may result in emergency suspension pending the physician's license. Now, it used to be the case that when you receive the initial letter and the complaint summary, it would have a priority number. And if it's a priority number 1 case, you knew it was fast track and that there was a possibility an emergency suspension could be issued. That's not really the case anymore. It doesn't matter what priority the case is being treated as, they may still move for an emergency suspension. Therefore, it's important that you immediately contact an attorney to review what the allegations are and whether it's something that they do have the right to pursue an emergency suspension on. Providing a copy of the physician's CV, again, I already addressed this, but you are under no obligation to provide a CV or any statement to the department. Believing that if they just explain it, the investigation will be closed. This is something we see all too often with physicians. They believe that if they can just have the opportunity to sit down with the investigator to explain their side of the case, the investigator will understand and the charges will go away. You need to realize that the investigator has limited medical knowledge. He's not there to make a determination. He's simply there to collect as much evidence and as much facts as he possibly can to use against you later. Failing to submit a timely objection to a DOH subpoena when there is valid grounds to do so. As we previously discussed, the Department of Health does have subpoena authority. However, there may be certain grounds on which you can object to that subpoena. The Department doesn't have any independent grounds on which it can enforce a subpoena. It has to go to circuit court to do so. Therefore, if you are going to make an objection, it has to be timely. Failing to forward a complete copy of the patient medical record when subpoenaed by the Department of Health investigator when no objection is going to be filed. This is something I've dealt with actually in the last couple of months. If you are going to send a patient record to the Department of Health, you must send the complete record. Don't delegate it to someone in your office. Don't take the perfect parts that you think apply to the case, because you don't know what you're sending them, and ultimately you may have record keeping complaints against your license, and you can get yourself into a lot of trouble by not fully complete patient records.